Brendan Dillon. I'm the managing partner of Dillon Solicitors in Rathfarnham, and today I just want to discuss about how we approach family law cases, and in particular the clients whom we represent. Well, I think the initial meeting is hugely important. Clients that come to us in a family law context are obviously upset. It's a huge trauma in their lives, and I feel that it's our job to listen to them first of all, hear their story and take detailed notes, and at the same time try to manage their expectations as to what a likely outcome will be, and if at all possible to give them reassurance into how matters will proceed, and where there are children involved, to try and focus on the best needs of the children. I think initially when clients come, they know very little about the process, and I think it's important to explain the various options in which they can be separated. Most people who are going through a separation or divorce believe that the only way to do this is by way of a difficult and costly court process, and of course that isn't always the case. So we will advise them in relation to the options such as mediation, collaborative law, which is an option where both parties are represented by solicitors, but where they try to work together to reach an agreement. Another option is a negotiated separation agreement, or indeed just a negotiated agreement which is then brought into court and is ruled as a court order. So there are many options available to the parties, and they don't all involve a contested and acrimonious court process. Well, of course, family law can be contentious and can be difficult, and we sometimes receive letters from other side solicitors which can be difficult and which sometimes don't assist the parties move on. In that context, I believe that it's important that any letter that is sent on behalf of a client should be seen by the client. They know their husband or wife, as the case may be, and are probably in a better position to know how that letter will be received. Well, I certainly think that correspondence should be factual, it should be balanced, it should focus on the main issues that the parties need to resolve, rather than getting into any personalised attacks on the other side. That's not our role as solicitors. We are there as advisors. We're not there as cheerleaders as such for our clients, and sometimes we have to explain to clients that sending letters that may be inflammatory isn't of assistance in the overall context, and certainly where there are children involved makes it much more difficult for the parties to work together to parent the children. So the tone of the letters, we believe, is very important. Stick to the facts and the important issues. Well, of course, going through a separation is extremely traumatic and it's extremely difficult, so in as much as possible we will take the lead with our clients and try and stay ahead of the file, so to speak, and be advising the client on an ongoing basis of what the next steps are. We, of course, are very experienced in the area of family law. Our clients are not, and they require guidance all the time. So in as much as we can assist them and offer them advice as to how we can move the matter on, they are stuck in a very difficult situation, and the sooner the case can be resolved either by agreement or, if necessary, through the court process, the better for them. Yes, this is an important aspect of the work we do in family law. Sometimes it is very straightforward. If the clients are both P60 and their financial position is very clear, then the review of financial documentation will, in those circumstances, be fairly routine. However, this isn't always the case. And unfortunately, in family law cases, particularly in difficult cases, one or other of the spouses may decide that it's a good idea to conceal assets, or in some way confuse issues in relation to financial transactions. It is our view that that is not helpful, and when we are confronted with that, we have to carry out forensic review of the documentation. Sometimes we will bring in a forensic accountant, because the court will ultimately have to make a decision that amounts to what's called proper provision, which is a fair distribution of the assets, and of course that can only happen if there is a full disclosure and understanding of all of the assets and the financial transactions between the parties. Well, the word that springs to mind when I think of outcomes is fairness. That of course can be subjective, but ultimately if we can reach an outcome and help our clients reach an outcome that is fair, that is child focused, and allows the parties to move on with their lives with as little acrimony as possible, that's a good outcome for the client.